Everyone. Thank you for joining us today for our training on litigation for unaccompanied children, updates and foundational cases. This is the first in a series of 4 trainings that CILA will be hosting with NILA over the course of 2022. The purpose is to inform practitioners working on children's immigration matters of cases, whether out of the federal court or the BIA, that could impact their work and how they might be useful. My name is Vicki Gialvera, and I'm a senior staff attorney for the Children's Immigration Law Academy, or CILA for short. We are a project of the American Bar Association. To get started, I would like to welcome you all to say hello in the chat box. When you click on it, make sure it says to panelists and everyone, and you can include your name and your organization or firm. And we are really grateful that you are here with us today for this training. There are a few housekeeping items and reminders that I'd like to go over. This training is an hour and a half long. We anticipate that these trainings may lead to quite a few questions. So we have reserved the last about 30 minutes for questions. So we encourage you to submit your questions. Please use the Q&A function rather than the chat box to enter questions, so we can look through them and address the questions at the end. We are recording this training. CILA will post the training on our website in approximately a week or 2. Also, this training has been approved for 1.5 hours of Texas CLE credit. At the end of the training and via an email after the training, we will provide a survey for feedback and a survey for CLE, where you can request Texas CLE credit for attending. If you are licensed outside the state of Texas, you can also complete this survey and request a letter certifying your attendance. Okay. CILA is now entering into our 2nd year of collaboration with NILA, or the National Immigration Litigation Alliance, with this new series on litigation updates, joining a series of 12 webinars that were produced in 2021 on a multitude of topics related to appellate and litigation practice. Some trainings, like this one, were offered live, and many others were recorded. CILA has been posting all of the trainings on our website under Trainings and Appellate Litigation and Strategy. We have included on this slide the trainings that are currently posted on our website, so you can see what we have covered, that we have covered many topics in this partnership. I am really happy to be able to introduce our speakers today from the National Immigration Litigation Alliance, or NILA. The mission of NILA is to realize systemic change in the immigrant rights arena by engaging in impact litigation and by building the capacity of social justice attorneys to litigate in federal court. Our speakers today are going to be Trina Real Muto, the Executive Director of NILA, Mary Kenny, the Deputy Director of NILA, and Kristen McLeod-Ball, the Senior Staff Attorney at NILA. Trina has over 20 years of experience in immigration, damages, and transparency litigation in federal courts. She has litigated and argued several precedent decisions on behalf of individuals, classes, and amicus curiae, written numerous practice advisories, and is a frequent presenter on immigration issues. Mary, who unfortunately is in a hearing at the moment, but hopefully will join us later, has worked for 25 years to protect the rights of non-citizens, combat abusive conduct by immigration agents, and overturn unlawful policies of the immigration agencies. Prior to joining NILA, Mary was directing attorney of litigation at the American Immigration Council, where she engaged in impact litigation and authored numerous practice advisories. Kristen's career has been dedicated to defending the due process and statutory rights of immigrants. Prior to joining NILA, Kristen was a staff attorney at the American Immigration Council, where she co-counseled class actions, wrote amicus briefs for numerous courts of appeals, including in precedent cases, argued important cases, authored practice advisories, and organized AIC's annual litigation meeting. We are so grateful that they joined us today. So like I mentioned, the CILA and NILA partnership includes many trainings, but also resources. And additionally, for those who are in Texas, technical assistance can also be submitted to CILA. And you can get help with your appellate and litigation questions through our coordination with NILA. Our website is continuously updated and hosts a lot of helpful information. If the trainings and resources that I just mentioned are of interest to you, we encourage you to check out our website at cilacademy.org. You can also reach out to CILA via our technical assistance web form on our website or send an email to any of us on staff. Okay, now I'm going to turn it over to our speakers. I think first to speak will be Trinaria.
Thank you, Vicki, and hi, everyone. It is so nice to be back in 2022 with another round of collaboration with CILA, because they have been such fantastic advocates in this children's advocacy space, and it's been a joy to collaborate with them. And I know all of you who are getting technical assistance from their staff are very fortunate because of their dedication and their skill and their expertise in these issues. I just want to briefly introduce NILA to those of you who may not have been on a previous webinar with us or don't know us. And if you're joining for the first time, welcome. NILA is a newly formed in 2020 immigrants' rights organization. And we have 3 core programs that, that make up what we do. And if I could just talk briefly about those programs so that you know, and you can know how to utilize our resources and get in touch with us if necessary. One of the things that we do is impact litigation. And on that piece of it, you'll see on your slide some of the types of impact litigation we have done. And more particularly, we try to focus on systemic change in procedural issues, as well as substantive issues. But we tend to focus our newer cases on issues that immigration practitioners like you all have a problem with, that are things that keep you up at night, but don't have the capacity or time to litigate. So we're looking for procedural systemic change in our impact litigation. And an example of that is our class action in Nightingale, in which we forced a-file FOIA processing to take place within 30 business days. And we are continuing to monitor that injunction for an indefinite period of time to make sure that the government complies with that success. The other 2 programs that we have are strategic assistance and co-counseling, and that's really focused on helping folks who are out there on the ground representing clients in one of 2 ways. One way is strategic assistance, where we focus our assistance is generally on federal court litigation and strategy. We do some procedural work in removal proceedings around motions to reopen and absentia motions like Kristen's going to be talking about. And so on. But we also strategize with people who are new to bringing cases to federal court, or some of our members who've been practicing for a really long time and are just looking for a thought partner. And we will get on the phone with you or respond to your emails and your phone calls. We'll look at your documents and help you think through what to do next in your case. For people who are members of NILA, we'll also review pleadings for a very reasonable fee. We'll give line edits and high-level comments on written products. And we also have practice advisories, which are available to everybody on our website. And lastly, I just want to let folks know about our co-counseling program. If you are new to litigating in federal court, this is a great opportunity to be able to go into federal court with one of us, Mary, myself, or Kristen, so that you have a co-counselor who's sort of done it before and is there to help answer your questions and guide you through that process. We accept cases on a case-by-case basis based on our expertise, the issue, the availability of other attorneys to do the case. But we basically litigate in a lot of different circuits and a lot of different courts around the country. And you'll see on your slide the types of cases that we co-counsel. Co-counseling is governed by an agreement where we lay out what the roles are of each entity, and we set some internal deadlines. And if you want to learn more about it, you can check out the testimonials that are available on our website. And so without further ado, that's NILA. Without further ado, I'll turn it over to Kristen to begin this new phase of presentations with CILA.
Thanks, and thank you everybody for being here today. So we're gonna give a talk about several federal court cases, right? Some PFRs, some affirmative challenges to agency actions that could impact your work representing children in various parts of the immigration system. So some of the cases that we're going to talk about today have new decisions that you may not be deeply familiar with yet, or even remain ongoing in the federal courts, where others are sort of old standbys that we want to make sure you are utilizing to the fullest extent that you can on behalf of your clients. So for all these different cases, we're going to give sort of a rundown of the facts, some legal background that's important to understand, holdings, and key takeaways that you might want to think about from the different cases. And as Vicky mentioned, at the end, we're going to have plenty of time to respond to your questions about any of the cases that we've talked about and sort of the issues that they bring up. So keep that in mind. If that sounds good, I'm going to jump right into the first couple of cases that we're going to be talking about. And they both involve challenges to in absentia removal orders. So I'm sure many of you guys have clients who were unable to or did not go to removal hearings and ended up with orders of removal that were issued in absentia. The basic process for challenging this type of order is filing a motion to rescind the in absentia order. The statutory requirements are set out in 8 U.S.C. 1229A subsection B5C. And they can be either based on lack of notice or because a failure to appear was due to exceptional circumstances. What I'm going to be talking about today is first, a decision from the Fifth Circuit from last year that sort of expands on what lack of notice that warrants rescission of an in absentia removal order looks like, based upon the Supreme Court's previous decisions in Niz-Chavez and Pereira. So that's the case you'll see on the screen in front of you right now, Rodriguez versus Garland at 15-4-351. And then I'm going to turn to sort of a subsequent Fifth Circuit decision that unfortunately limits some lack of notice arguments. In that case is Spagnol-Bastos versus Garland. And I'll also touch on a recent related BIA decision on similar issues that is deeply unfortunate and will complicate the arguments that we're talking about here, especially outside of the Fifth Circuit. So that's sort of a preview of what's coming. Okay, so in Rodriguez versus Garland, to get into what the Fifth Circuit is doing here, unfortunately, we need to take a step back and remind ourselves of two Supreme Court decisions that you may well be sick of hearing about. Not sick of, they're great, so you're probably very excited to keep hearing about them. Niz-Chavez and also Pereira. As a quick recap, right, in 2018, the Supreme Court considered an interpretation of the stop time rule for cancellation of removal, which is triggered when someone is served with a notice to appear under 8 U.S.C. 1229 subsection A. The court found that notice has to include the time and place of hearing because that's required by the NTA statute at 1229 subsection A in order to actually trigger the stop time rule. And subsequently, in Niz-Chavez, the court again looked at the meaning of that notice to appear statute in the context of the cancellation stop time rule. And the court found that a problem with the notice to appear, the failure to comply with the notice to appear statute can't be cured just by sending a subsequent notice of hearing that has the information that was left out the first time around, right? It has to come in one singular notice because that's what the statute requires, and the government's obligated to comply with the statute. So those two cases have led to just a plethora of decisions in a variety of contexts, right? There's obviously a lot of decisions about what this means for people seeking cancellation. There's decisions about what it means in voluntary departure applications. There's attempts to sort of apply it to jurisdiction. We're not talking about any of that what we're looking at here is how that impacts motions to rescind an in absentia removal order. Why are they relevant to in absentia removal orders? Well, the statutes governing when an immigration judge can issue a removal order in absentia, and that's at 8 U.S.C. 1229A, subsection B5A, and the statute governing when those orders can actually be rescinded and reopened for lack of notice, that's at B5C2. They rely and cite the same notice to appear statute that the Supreme Court interpreted in Niz-Chavez and Pereira. So these arguments go, what the Supreme Court said about the notice to appear statute in the context of cancellation of removal should also apply in other places where that same statute is applied and interpreted. So that's a lot of background, but that's what it's important to know to sort of look at what the Fifth Circuit was doing in Rodriguez. Rodriguez was issued last year, and it's a case in which a petitioner was served with a notice to appear that, like the folks in Pereira and Niz-Chavez, it did not include the date and time that the removal hearing was actually going to occur. So that's a notice to appear that doesn't comply with the requirements of 8 U.S.C. 1229 subsection A1, sort of what we might call a Pereira non-compliant NTA. EOIR then sent a notice of hearing to the address that the petitioner had on file, right? The notice of hearing tried to supplement what was in the notice to appear. It had the missing time and place information. However, the petitioner never got that notice of hearing, so he did not go to the hearing, and the IJ ordered him removed in absentia. It's sort of interesting to note that this individual, I think, had moved away from that address. That didn't become relevant to the holding, but that's why he ultimately didn't get the notice that was subsequently sent. So when this individual figured out that he'd been ordered removed, he did what he was supposed to. He filed a motion to rescind the order based on lack of notice. And he made the argument that we were just talking about, that, you know, an in absentia order requires notice as set forth in the notice to appear statute. His NTA did not include that notice, and so it wasn't proper, and he met the requirements for filing a motion to rescind based on lack of notice. The IJ that he filed with did not buy it. The motion was denied. The denial was affirmed by the BIA, and then the case reached the Fifth Circuit on a petition for review. What happened there was great. The Fifth Circuit issued a decision that was good for immigrants in removal proceedings. Essentially, the court looked at what the Supreme Court had said in Niz-Chavez, saw that the court required notice under 8 U.S.C. 1229A to be under a single document, saw that the in absentia statute at 8 U.S.C. 1229A subsection B5 also relied on individuals receiving notice under 1229 subsection A, and so found that the Niz-Chavez interpretation also applied in this context, right? So the Fifth Circuit found that because the NTA didn't require the time and date information, it didn't satisfy the written notice requirements of the notice to appear statute, and so therefore also didn't satisfy the requirements of the in absentia statute. The BIA's decision to the contrary was contrary to the Supreme Court's decision in Niz-Chavez, and so the Fifth Circuit vacated the BIA's decision, remanded for proceedings consistent with Niz-Chavez. Again, like I said, great news. However, there are some caveats both for people practicing in the Fifth Circuit and those in other locations that I want to talk about. But you know, the quick sum up is this means that people who didn't receive, who received NTAs that weren't Pereira compliant, that didn't have the time and date information, could potentially seek to reopen, and then were ordered removed in absentia, can potentially seek to rescind the in absentia order based on a lack of notice, using this statutory argument. So caveats. First, unsurprisingly, the government was not super excited about this decision, and so there's a pending petition for rehearing in this case. The court called for a response by the petitioner last month, so that's been filed. It's all, sitting and pending before the court. Who knows what will happen, but essentially that means that there's a chance that the case will be reheard en banc and that the existing decision could be vacated, which would be bad news. Next, outside of the Fifth Circuit, no decision like this exists. This is sort of the only decision like this that we have. And in fact, last week, the BIA decision issued a contrary published decision in a case called Matter of La Parra. That's 28 INN decision 425. La Parra essentially says if you get a Pereira non-compliant NTA, you get an NTA that's missing the time and date information. As long as you get a subsequent hearing notice with that information, that's all you need for an in absentia order. And so there isn't a basis to file a motion to rescind. So if you're practicing outside of the Fifth Circuit, if you file a motion to rescind on this basis, really looks like you're going to get a denial by the IJ, and that the BIA would affirm that denial. You can and should still make this argument. Bad BIA decisions have been overturned in the past. We don't know what will happen in this case, but I think you do need to know that you're likely going to need to pursue a case all the way to the petition for review stage to succeed on this issue in other locations, is what it seems like right now. I'm happy to, if folks have questions about La Parra and sort of ways that arguments you could use to challenge that, I'm happy to talk about that when we get to questions. But I will say, La Parra, the BIA really focused on sort of minor distinctions in language between the cancellation of removal statute and the in absentia statute, the use of the word a in one statute and not the other, and the reference to notice under the notice to appear statute or the notice of hearing statute in absentia statute. So there are arguments that you can make against that about why they're wrong, but it's out there and it's going to be a problem for people making this argument in other places. The last point I want to make is that even in the Fifth Circuit, even with Rodriguez standing as good law, you may run into trouble with this argument if your client didn't receive notice, but also provided EOIR with a deficient or non-viable address for their records. So didn't provide an address at which they can be reached to get a subsequent notice of hearing. This comes up in the next case that I'm going to discuss, which you'll see on the slide right now, which is Spaniel Bostos. So, okay. This is another Fifth Circuit case from last year, and it actually arose from pretty similar facts. It's another case where the petitioner was served with an NTA that did not have the time and date of his hearing. The NTA did like all NTAs do. It told the petitioner that he was required to provide immigration officials with a current address where he could be reached for subsequent notices. And he tried to do so, but the address he provided contained an error. And so the mail that was sent to that address was subsequently returned to EOIR as undeliverable. Because of that, he didn't get his hearing notice, he didn't go to court, and he was ordered removed in absentia. He later filed a motion to rescind. And this one actually wasn't based on the Niz-Chavez argument. It was, I think, filed before that decision came out from the Supreme Court. It was based on sort of what had happened with providing the bad address to DHS and who had misrecorded it and sort of issues around that. So in any case, he filed a motion to rescind based on lack of notice. It was denied by the IJ, BIA affirmed, and the case again reached the Fifth Circuit on a petition for review. This time, it's not a great decision from the Fifth Circuit. The court found that essentially the petitioner had forfeited his right to receive any notice at all by failing to provide the address required under 8 U.S.C. 1229 subsection A1F, which requires providing a written record of address at which an individual can be contacted, as well as updates to changes in that address. The court found if you don't comply with this address requirement, then under 8 U.S.C. 1229A subsection B5B, written notice is not required before issuing an in absentia order. So someone who doesn't provide a viable mailing address forfeits the right to notice and can't seek to rescind for lack of notice. Notably, despite the fact that it came out after Rodriguez, it didn't really discuss at all how Rodriguez impacted this portion of the decision, or how Niz-Chavez impacted this portion of the decision, perhaps because those cases were not raised in the opening brief here. But it does mention that Rodriguez is distinguishable because the petitioner in that case provided a viable mailing address. The decision also got into this individual's cancellation of removal claim. It's not related to the in absentia stuff that we're talking about here, but it's sort of notable to say this guy might have had a viable cancellation claim, but because the argument wasn't raised in the opening brief, it was treated as forfeited. So important to always preserve all arguments whenever you possibly can. Okay, so what does Spagnol-Bastos mean for folks? Aside from the fact that I think the case is not great, it has some not great analysis in it. This is another one where you should be keeping your eyes out for developments. The petitioner filed a petition for rehearing, which is pending before the Fifth Circuit. So, keep your eyes peeled in case anything happens on that. In terms of what to look out for in your own motions to rescind going forward, you need to think very carefully about how to show that your client provided a viable mailing address, right? As always, I think you want to treat this bad decision as narrowly as you possibly can, right? This is a case where someone provided an address, mail sent to that address was returned as undeliverable. So that should be what not viable deficient address means. You sort of note that they distinguished it from Rodriguez, where the person provided a real address that they weren't living at anymore. So that's something to note. Also, you guys are working on kids cases, and note that Mr. Spagnol-Bastos is an adult. And so the cases analysis about, providing notice and forfeiting your rights should be taken in the context of the requirements that would apply to an adult here. Also, more generally, like I was mentioning earlier, this case is a good lesson in why you should always preserve all possible arguments, right? Even if you think an argument is not viable right now, before the IJ, before the BIA, in your Court of Appeals, you never know how the law is going to change or what sort of decisions are going to be issued. So preserving all possible arguments in all of your motions, all of your appeals, all of your federal court briefs will serve your clients well. Make sure you don't forfeit or fail to exhaust arguments that could come back and gain new life in the future. Okay, so that's a bit of a talk on those two cases. And now I'm going to turn it over to Trina to talk a little bit about an asylum decision.
Thanks, Kristen. Oops, there we go. I wanted to talk a little bit, move us away from sort of the new case and just focus on an oldie but goodie, because this new series that we're doing with CILA is focused on new cases, but also reminding folks of cases and concepts that, are presumably applicable and for the long term. And that's what we're going to talk about now in a case that I'm probably going to mispronounce, but it's called, I think, Kolayevsky versus Mukasey out of the Seventh Circuit. And I'll just start with the note that this is just one of cases that have held this concept that we're going to be talking about, which is that persecution really should be viewed from a child's perspective, and particularly at the time that the persecution happened. That's what you're looking at, even if the child is no longer a child. You look back to that period of time where the person happened, and you look at what the impact is on a child of that kind of persecution. And so that's a concept that's really important when you're representing kids in asylum cases and fear-based claims in general. And so we wanted to just look at this one case because, it's a very clear factual scenario of what happened to the petitioner, who I'm just going to call, instead of trying to mispronounce his name every time, Artiego, his first name. And I should also say, for those of you in the Seventh Circuit, this case name may sound familiar because there's other permutations. There were other petitions for review. There was a habeas case involving other issues, the custodian rule, etc. But we're focusing on just one of these cases. And I think largely that's because his attorney, Maria Baldini-Porterman, did everything she possibly could for this client. So there's different cases, but this one is the 2008 decision that we're talking about. So Artiego factually is from the former Soviet Union, and he was facing religious and ethnic discrimination by other children based on his Jewish ethnicity when he was between the ages of 8 and 13. And the mistreatment was really, gruesome for a kid, especially when you're looking at a kid of that age. There was name calling, he was urinated on. He had his pants pulled down in the bathroom and kids were laughing at his circumcision. He was beaten. Some girl had her German shepherd sick him and bite him. And he ended up having to go to the hospital and getting 40 rabies shots. And all of this really traumatized him to the point where he had to drop out of school and he was hiding in his family's, apartment. And his family was also at the time experiencing threats and harassment. There were threatening phone calls. The Star of David was etched in their mailbox. But in 1992, they managed to get refugee status in the United States. And Artiego later came to the US and became an LPR. But as a result of all this trauma that had happened to him, he gets into some criminal trouble, and he's having panic attacks, and he's having sustained a number of convictions which lead to him being placed in removal proceedings. And so before the immigration judge, he's applying for asylum, and his mother is testifying to the past abuse, as is he. There's a medical expert that comes in to talk about his mental conditions, but the IJ denies asylum, as does the BIA. And there's a PFR, petition for review, that goes up to the Seventh Circuit and then goes back down. And it's back on remand where the board sort of ultimately denies his claims. And so the case goes back up to the Second Circuit on the second petition for review. And there's lots of issues about expert testimony, IJ bias, prior refugee status, all kinds of stuff like that, future persecution claims. It's a big decision. But the part of it that I think we're talking about and reminding folks of here is the piece that's relevant to assessing persecution at the time that it happened and taking into consideration the child's age. And so the Seventh Circuit in this case held that the board didn't apply the correct standard to his past persecution claim because it didn't consider the fact that he was between 8 and 13 at the time of these incidents happened. And it didn't consider what the impact of those kinds of actions are on a child of that age. And the court very clearly said that the persecution assessment really requires examining both the nature of the abuse and the age of the petitioner at the time the abuse happens. And the court sort of slaps the BIA down for giving short shrift to the incidents that happened in Artiego's past, and found that they didn't evaluate what the impact is, for example, of having his pants pulled down in the bathroom, how that would impact a kid of that age. I think he was like 8 or 9 at the time that happened. And so the court sent it back down and basically said to the BIA, now you better assess this under the correct standard. So this case just, I think, stands as a good reminder of sort of, 3 principles that you're probably all aware of. And so hopefully this is coming out as a refresher for you. And that is just that the board has an obligation to consider the age at the time of the harm was inflicted and the impact when it's doing a past persecution assessment. That's the first thing. Secondly, one important thing to do, right, as a takeaway is that in order to have, the strongest possible claim for past persecution there, you're going to want to think about submitting evidence of, including, evidence on the psychological impact of the harm in question on a child of that age. And it could be specific to the person, but you could also put in, whatever types of reports that there are, from objective scientific sources about how children experience harm. And last but not least, and this is an important one, and I know for a fact that there are decisions under the Second and the Ninth and the Sixth Circuit, you have to qualify for persecution, you have to remember that the amount of harm to a child might be less than it is to an adult, right? So if an adult gets, perhaps, I don't know, inappropriately touched, that might not really rise to the level of persecution. But if that happens to a young person who cannot process what is happening, that is what you look at, and that might be enough to be persecution. And then I think it's consistent with, guidelines for assessing children's asylum claims that, that were cited in this decision from the Seventh Circuit, and I've seen cited in other opinions. And so with that, I think we will sort of move on to Mary, who we're happy is able to join us. But I just wanted to remind folks about that principle, and hopefully this case will be a helpful insight to you when you're briefing the issue.
Thank you, Trina. So I am going to shift gears again, and I'm going to talk about two SIJ cases that raise the same issue. And specifically, it's the issue of whether a person who has been granted SIJ is eligible for an employment authorization document when based solely on the SIJ status, and not, they don't have a pending adjustment application, they don't have a pending asylum application, so there's no other basis on which they are eligible for an EAD. And we all know how important those EADs are to the clients. Not only is it important for work, but it's important for in many places for being able to get a driver's license, a social security number. You can have obstacles, students, young people can have obstacles continuing their education. There are all kinds of ramifications that can arise from a person not having the EAD. So the first case was a case that was brought in the Western District of Missouri called Godinez v. US DHS. And essentially it involved 3 Guatemalan youth who entered the United States. They were minors when they entered. They subsequently were successful in getting SIJ status, and thereafter each applied for an EAD with proof of their SIJ. And USCIS denied those EAD applications. And the USCIS denied it on the basis that they could not prove that they were eligible for a EAD based on the provision, the regulation, which provides that an individual who has been paroled into the United States for either urgent humanitarian or reasons or for public benefit are eligible for an EAD. And that provision is 8 CFR section 275A .12 C11. And so again, the provision is EADs can be gotten by folks who have humanitarian or public benefit parole. And so USCIS said, no, there's no evidence that the SIJ status alone does not demonstrate that you are paroled for purposes of an EAD for humanitarian reasons. So after the denials, the plaintiffs filed a lawsuit naming DHS and USCIS, and the lawsuit was brought under the Administrative Procedure Act and the US Constitution. There were two claims, and they sought injunctive and declaratory relief. They asked the court to declare that the determination that they, as individuals with SIJ status, were not parolees was arbitrary and capricious and in violation of the law. And they asked the court to order USC to reopen their EAD applications and re-adjudicate them in accordance with the law. And the arguments that they made in support of this really hinged on the statutory provision, which indicates it's INA section 245H or 8 USC section 1255H. And it's the first paragraph in that provision. So it's H1. And it basically says that an individual in special immigrant status is deemed for purposes of adjustment of status, for purposes of 245A, the provision that lays out when an individual is eligible for adjustment of status, and that provision 245A requires that the individual either have been inspected and either admitted or paroled into the United States. So 1255 or 245, I'll stick with the INA site, 245H1 says that for purposes of 245A, for purposes of that inspection and admitted or paroled provision, the special immigrant juvenile will be deemed to have been paroled into the United States. So it won't matter how they actually entered and whether they received parole, they're going to be deemed or considered under the law to have been paroled for that purpose. So the argument essentially raised by the plaintiffs in Godinez was that indicated Congress's intent that the individuals, that the SIJ recipients were to be considered paroled for humanitarian purposes. And that's exactly what the EAD provision requires, and therefore that they met the requirement for an EAD. The government immediately, rather than file an answer, instead the government filed a motion to dismiss the lawsuit and argued essentially that no, 245H only applies for purposes of adjustment of status. It's limited to that, and it can't be read more broadly as indicating that SIJ recipients are actually paroled for purposes of an EAD. They're only paroled for purposes of adjustment of status. And the court did not accept that argument. The court looked at the larger statutory context, and it looked at the legislative history behind the SIJ provisions. And it said, no, Congress's intent here was to give a humanitarian benefit to these youth. And part of that is this parole provision. And basically the court said, defendants, USCIS and DHS, were reading into the statute, into 245H, the word only. They were saying that the Congress intended that they be deemed to be parolees only for purposes of adjustment of status. And the court said, no, that word only isn't actually there. There's no preclusion in the statute for deeming these individuals to be parolees for other purposes besides adjustment of status. And looking at the larger intent, Congress's larger intent behind the statute, humanitarian intent, the court said, no, I find that they were really, the whole purpose was humanitarian, and therefore they satisfy the purpose of being humanitarian parolees. And so the court rejected the defendant's motion to dismiss on that basis. After that, the parties ended up settling the lawsuit. Essentially, my understanding of what happened was that the individual had a either an I-130 or an I-140, but the priority date became current, and based on that, the individual filed an adjustment of status application. And two of the plaintiffs had been, there were 3 plaintiffs altogether, 2 of them had been dismissed earlier on, and there's no indication in the record as to the basis for that dismissal. But the third remaining plaintiff, what happened, why they settled, was that this individual became eligible to apply for adjustment. And as soon as they applied for adjustment, they became eligible for an EAD based on that pending adjustment application. And so they no longer needed the EAD based on their SIJ status. And for that reason, the issue became moot, and the parties agreed to dismiss the action. So there was never a final ruling by the court on summary judgment, but the ruling of the court on the motion to dismiss remains extremely significant. It's the only decision out there on this issue that addresses the question of whether an SIJ recipient is eligible based on that SIJ status alone for an EAD. Following up on the law, this decision, there was another case, and if we can move to the next slide, we'll talk about that. LFOP v. Mayorkas, which is a case that was filed back in September in the District of Massachusetts, and it was filed as a putative class action. So it was filed by named plaintiffs on behalf of similarly situated individuals who reside, similarly situated SIJ youth who reside in Massachusetts. The government, and it raised the same issues, it raised the same claims as in Godinez. It laid it out a little differently. In particular, rather than challenging individual denials in LFOP, the plaintiffs are challenging a nationwide policy of the defendants of DHS and USCIS of refusing to issue EADs to SIJ youth, and saying that policy is unlawful. So they're challenging the policy in specifically. And in fact, at least initially, none of the named plaintiffs had all applied for an EAD, but they hadn't been denied. But they were saying the denial is going to happen because of this policy, that this binding policy on USCIS adjudicators that precludes them from granting an SIJ recipient an EAD. They made the same arguments. They made the same arguments around the fact that 1255H has to be read broadly and in context and consistent with legislative intent. And that reading would be that these individuals are deemed in a larger sense to be humanitarian parolees. And as a humanitarian parolees, they would then be eligible for an EAD under 8 CFR section 275A.12C11. So in response, the government filed a motion for a stay of the proceedings and a stay of having to file an answer or a motion to dismiss in early December of last year. And in the stay, they said USCIS is considering a change to this policy, and therefore we're requesting that the court hold off, stay the case until USCIS has a chance to conclude its review of this policy and decide whether or not to make a change, and if a change is made, implement a new policy. The plaintiffs opposed that request for a stay. They argued that, among other things, they argued that there was no indication by the defendants that the policy, in fact, would be changed. It was all sort of speculative. Maybe DHS and USCIS would change the policy, but nothing definite that they would change. So there was sort of this speculative request behind they were asking for the case to be put on hold based on an unknown outcome of this internal review that was happening. That was one basis. And then the second basis was that it was severely prejudicial to the plaintiffs, that every day that an individual is within an EAD, they suffer harm. And there was this, not only the named plaintiffs, the individuals who filed the lawsuit, but also the putative class members are all suffering harm, and the court should move forward with the case as expeditiously as possible because of that harm. Right at this point, the court has not issued a ruling. Let me back up. Soon after that, in early January, the plaintiffs then filed their motion for class certification. And so they actually put on record that they are applying for class certification. That motion and the defendant's motion for stay are all pending before the court. The motion for class certification is not fully briefed yet, so it's not actually ready for a decision, but briefing is ongoing and for that motion, and the motion for stay is pending, and there's been no decision. But in the stay request back in December, when the government applied for this stay, they attached an affidavit from a person within USCIS who indicated that there was a fairly high level evaluation of this policy being undertaken, and that it was possible that a decision would be made within 45 days of the date of the stay request. The stay request was dated December 10th. And so the 45-day, no, it wasn't December 10th. Let me see.
December 27th, I think.
Thank you. That's what I was about to say. Thank you, Kristen. It was December 27th. And so the 45 days would be up in early February, I think around February 10th. So there may be a new policy by that date. Now, the same person who submitted that declaration included in her declaration that there was no guarantee that they actually would keep to that timeline. So, we don't have any idea whether there'll actually be a decision made by the agency by early February about whether or not there will be a new policy, about whether or not they're going to be granting EADs to special immigrant juveniles. Given USCIS and what we know about USCIS and how long it takes them to do things, I think there's a very good chance that that date will come and go, and there will not yet be a policy, but we don't know. And so it's important. I think the most important tip to come out of the discussion on this case is to be aware that there may be a forthcoming change in policy and to watch for it. So that's all I have on this case. And I think we're going to open it up in general to questions on any of the cases.
Awesome. Yes, thank you so much, Mary, Trina, and Kristen. And like I said at the beginning, we know that you all have a lot of questions, so we're going to go ahead and open it up. And I think my colleague Yasmin is going to assist with reading out the questions.
And it looks like there's already a few in the chat box, so we can jump in and start with some of those. Oh, sorry, there's Yasmin.
Kristen, if you have any, if you can see them and there's any you want to tackle right off the bat, please feel free.
Sure.
I can also read them to you. What do you prefer?
Well, I'll start out with the first one, and then we can go back to the other format. Sorry. So the first question here is about the first question here is about the Pereira and Niz-Chavez issue that I was talking about earlier, and whether there are developments on the jurisdictional arguments that are related to that. And so sort of as a recap, right, we were saying Niz-Chavez and Pereira apply to a lot of different contexts. One of them was the in absentia situation that I was talking about earlier. Another argument that many people have tried to make is
Did Kristen freeze for you all too?
Yeah, I think so.
Give her a second. She may have to jump off and get back on.
Yeah, I think she was nearly done.
So can I jump in and correct a couple of things I said?
Sure.
So I had looked at the docket for LFLP last week, like Wednesday or Thursday, and did not have a chance this week to look again. And Dahlia just indicated that the stay in that case was actually denied on last Friday. And so that's really good news. That means that the case will be moving forward. There still may be a change in the policy, but at least we know that now the case is moving forward. So thank you, Dahlia, for that correction.
While we wait for Kristen, there were a couple of questions about SIJ and EADs. One that came in just through the chat is, do you suggest going ahead and filing EADs for SIJ clients or waiting for a decision? And I don't know if anybody has any thoughts on that.
Oh, I was thinking about that, and I'd love for you, Yasmin, and Vicky, and others at CILA to weigh in on this, because you're more knowledgeable about SIJ than we are. It seems to me that it's worth waiting at least until mid-February to see if, in fact, there will be a change in the policy anytime in the very near future. Beyond that, it might be worth touching base with counsel for the plaintiffs in LFLP to see if they have any update on when there may be a change in policy. And if they don't, then I think you have to decide, there are a number of things to take into account in terms of whether or not to apply. If there's no change in policy, then this case could go on for a while. It's only effective for Massachusetts. I mean, if the class is certified, it's only Massachusetts residents. And so it's not going to have any precedential value in other places. And so if there's no change in policy, your client, in order to succeed, would have to file a lawsuit themselves. But on the other hand, if there is a change in policy, you'd have teed up that application. And so those are things I think you would need to weigh and discuss with your client. But I'd be curious if you all have other thoughts in addition to that.
Yeah, I actually do, Mary, because I've gotten this question as a TA before. And because we know that people, not just in Texas, kind of around the country, we're trying to use kind of Godinez as the example that, these cases should be approved under C11. And so what happens now that that case has been settled? Like, what happens to that, language? Can it be used effectively, like as persuasive, I suppose?
Absolutely. And in fact, it's being used in LFLP in the complaint. And I may have also seen them cite to it in the motion for class certification, but it definitely, I'm sure they'll cite to it when they get to summary judgment. But it's only persuasive. You're right. It's not precedential because it was a Western District, Missouri case, and it doesn't have any impact beyond the individuals in that case. And it was only a motion to dismiss. So it doesn't, at any rate, it doesn't even, make a final ruling on what the law is.
Along on the same sort of thread, we had a question in the Q&A. In your experience, have EADs been issued for special immigrant juveniles? I have seen on listservs that RFEs are being issued. We actually got in the chat a comment that at CLS, we do make the argument to USCIS about the parole category for SIJ applicants, and they get approved 60% of the time. So it sounds like some people do have some success. Vicky, I don't know if through TA you've seen other people have success.
I would say that's true. I would say it's kind of hit or miss. I know when I was doing it, which was several years ago, we got the occasional one approved with C11, but I was kind of slipping them in with some other humanitarian C11s. But the one thing that I have heard recently is that if you're asking for an EAD under C11, they're now asking for an I-94. And that is something that SIJS is not, they're not going to have. And so that's where the RFEs are coming from, I believe.
That's interesting because that is part of the claim that was made in LFLP that in all of these cases that they're saying I-94s are being required and SIJ recipients are not able to get I-94s.
We have a couple of questions about Jacoby Garland, or Jacoby Garland, I'm not sure how you pronounce it, which wasn't a subject of today's webinar, and I think we might save those because we're actually considering covering that case in a future webinar like this one, so we will save those.
Yasmin, can I jump in? I know that Kristen is having internet issue and needs to call back in if she's going to join, but I did see one question come in about arguments to get around matter of La Para, and I thought that I could go ahead and answer that. You know, NILA has a template motion to rescind based on lack of notice that is on the CILA website, and it's on it's on our website and it's in Word, and it makes the arguments about the statute that Kristen was talking about, and it basically makes some of the same arguments that the Fifth Circuit adopted. Now we have this matter of La Para decision. And so when you're bucking up against a BIA decision, you're doing two things. You're making an affirmative argument. This is how the statute should be interpreted. And then you're looking at matter of La Para to say, hey, what did they do wrong? And often it's like two sides of the same coin, right? What they did wrong is they didn't adopt our interpretation of the statute. But she was starting to talk a little bit about how the BIA's decision really focuses on the fact that the statute uses the word the, whereas Justice Gorsuch in Niz-Chavez was focused on the fact that the statute said a, and you would sort of make the argument that that's like form over substance, that that's not really, you know, the gist of it is the statute should be interpreted the same way for both purposes and make those kinds of attacks. And you know, we know for a fact that the petitioner's attorney in La Para is going to be challenging that case up to the First Circuit. And so we know that the issue is going to be before the First Circuit and likely to get resolved for that circuit quickly. And we're hoping, you know, hopefully it'll be a good decision and that'll be helpful. And then you'll have a good decision in the First Circuit and the Fifth Circuit, hopefully. But I do want to say that even if the case wins in the First Circuit, it only applies in the First Circuit. It doesn't, even if it's a precedent decision, it doesn't invalidate it for the whole country. So what is going to happen is it's going to go circuit by circuit, these challenges to matter of La Para, you know, unfortunately. And so that's, you know, a long-winded answer to that question.
That's super helpful. Thank you. I think we're trying to get call-in information to Kristen, but while we wait for her, just one question that
I think time out. I think she's on. You just need to unmute her.
Ah. I'll give Vicky a second. I will just, one of the questions actually asked about the decision you talked about, Trina, the asylum decision. It says, how does that decision affect the government's argument in asylum cases that the child aging out is a changed circumstances that overcomes the presumption of a well-founded fear after they've shown past persecution? And I know that we've seen this in technical assistant requests more previously than now, but I think there is some case law, and people should definitely feel free to reach out to us for technical assistance, that talks about the fact that you know, the child aging out is sort of a personal circumstance, and changed circumstances that should overcome the presumption should really be more along the lines of country conditions, country circumstances. So if anybody is facing that issue, then you should definitely feel free to reach out to us. Okay.
I think we have Kristen now.
Yay.
Yes, I'm back. I'm so sorry.
It's okay.
No worries. We answered a few of the other ones, but Kristen, I know that you were in the middle of talking about the jurisdictional issue. I don't know if you want to take it back up.
Oh, sure. So the long and short of it is that, you know, the courts have not been receptive to the argument that under the regulations, there's no jurisdiction if there's a non-prayer compliant or prayer non-compliant NTA. And that's because I think in part the regulations don't specifically cross-reference the notice statute, which the Supreme Court was interpreting in Pereira and Niz-Chavez. And so if you look at the La Parra decision, there's a footnote that sort of lists out a broad array of Court of Appeals decisions declining to recognize the jurisdictional argument. One, you know, potential bright spot is that the Seventh Circuit discussed sort of the requirements of an NTA complying with 1229 subsection A, which is to say having the time and place information as a non-jurisdictional claim processing rule. And so if you timely raise it and say, you know, this proceeding shouldn't go forward because there's not a sufficient NTA, the Seventh Circuit said that the IJ should terminate proceedings without making show that there's prejudice. But that only applies in a really limited set of circumstances, right? Because that's timely raising it, like raising it when you get to court and the proceedings are starting, not as a basis for a subsequent motion to reopen or something like that. And so the other decisions from the court sort of on this issue would say that if you're not timely raising it, then you would have to show that there's some sort of prejudice connected to you know, the use of this non-prayer compliant and non-statutorily compliant NTA.
Very helpful. Another one on Rodriguez v. Garland, does the decision mean that IJs cannot issue an in absentia removal order if the NTA is deficient?
Oh, so that's a really good question, right? So if you look at the statute that's about in absentia orders, there's several subparts. So this is 1229A B5. And if you look at subsection A, that talks about what the requirements are to actually issue an in absentia removal order. And that's separate from subsection C, which talks about what you have to show in order to get an in absentia order that's already been issued rescinded. And so Rodriguez was about a motion to rescind an in absentia order, right? That's under C. But the same logic sort of applies to A. So I think you could make an argument that you know, an IJ shouldn't be issuing an in absentia order at all with regard to this sort of in a case that's started by this sort of NTA. But you know, realistically, that's something that would have to be raised at the time this hearing is happening, right? So the much more frequent situation in which you're going to be making this argument is there was an order issued at some point in the past, and now you're seeking to rescind it. But you know, theoretically, it could also apply to whether the order should be issued at all.
Yeah. Very helpful. Another related question. from a legal service provider. We tried to argue against the issuance of an in absentia order in the Fifth Circuit. This was in El Paso around the time that Rodriguez v. Garland came out, for a child who had appeared at hearings initially and then went missing. We argued that an in absentia order was inappropriate due to the defective NTA. Ultimately, the IJ decided that because the child had previously appeared and submitted to jurisdiction, there was no Rodriguez argument. And the question is, do you guys have any thoughts on this?
Appeal.
Yeah. And also just be careful about the way that it's framed, right? Because if they were interpreting the argument as being about jurisdiction, then it might fall back into that set of cases that are talking about sort of jurisdiction over proceedings and that regulation that doesn't reference the statute and all of that, as opposed to sort of authority to issue an in absentia order. So you'll just want to be sort of careful about that in terms of framing, you know, your ask and what the IJ did in that case.
And definitely, if you're interested in appealing anything like that, you can always reach out to CILA and we can connect you with NILA for technical assistance on something like that. Another question, what does it mean with the Rodriguez case that the BIA disagreed with it? What happens? Does that set up a new legal fight?
So I don't know, Kristen, I don't want to jump in if you were going to answer that.
No, you go ahead.
Okay. I mean, so interestingly, like sometimes the BIA will say, oh, and we're going to carve out, you know, the Fifth Circuit and we disagree with it. I mean, the way, and this is just the principle of immigration law, right, that we all know, the board decision governs unless there's a contrary circuit or Supreme Court precedent. And here we have the Fifth Circuit's decision interpreting the statute in the first instance here. And so, you know, people in the Fifth Circuit should argue that, and forcefully so, that Rodriguez remains good law, because this is an interpretation of the statute. You don't get into sort of that other stuff about deference, et cetera. Fifth Circuit said this is how the statute is going to be interpreted, and people in the Fifth Circuit should you know, forcefully advocate in their Rodriguez motions that that decision applies.
Great. This one is on Spagnol-Bastos. Are there other ways to forfeit your right to notice? So that decision right said that providing a deficient address, I guess, or a wrong address was a way to forfeit your right. Are there other ways from the decision?
Yeah, so, you know, the decision made that seem like just a thing you can do, forfeit your rights to notice, like it's a real thing, which is, you know, not generally, like you generally are just supposed to get notice. What they're referring to is a really specific statutory provision in the in absentia statute. It's subpart B, and it says that no written notice shall be required under subparagraph A. That's talking about the requirements for issuing an in absentia order. If the individual has failed to provide the address required under the notice to appear statute, right? 1229 subpart A1F. So it's very specific. It's just you didn't provide the address that we're saying you had to require, that you had to do by statute. The statute also says you have to update your address and your telephone number with them. But that's the only thing that this decision is talking to. It's not talking about some like broader concept of forfeiting a right to notice.
Very helpful, thank you. I'm checking, sorry, for more questions as they come in. We just got one in the chat that was just asking about which organization said they had 60% of their EADs approved. I think this was, I'm looking back now. I think they were using
CLS.
C11, was it, which one was it, Vicki?
The organization was CLS. Maite Barrientos said it. She put it in the chat. Oh, yep, there she is.
And they use the parole category. So
yeah, the C11.
C11 category, yeah. I just wanted to make sure I got that right. Okay, another question. Are there other ways to fight an in absentia order besides no notice and exceptional circumstances?
Sort of. So the two statutory provisions in the in absentia statute are just that: no notice and exceptional circumstances. You can also always request that the immigration judge reopen sua sponte, or you can pursue the general kind of motion to reopen that you would pursue for an in-person order, and argue that there's a basis for reopening under sort of the general motion to reopen statute, which is not super likely to succeed, but is a possible ask.
Great. If we have any other questions. I did want to highlight for folks that you should have received the slides in advance of today's webinar, which we don't usually do, and also the handouts, which are these really helpful write-ups that NILA did that lay out the procedural history, the facts, and the sort of key takeaways from the cases. And I think our goal is with each webinar in this series to add to that packet of decisions so that by the end of the year, you have a really helpful resource with all of those summaries. So just a reminder that you have those, and if you haven't received them, you can always let us know. I don't know if anybody else has anything else to add. If not, we can put the survey links and information in the chat for you guys, Vicki.
I think we did get 2 more questions.
Oh, whoops, I didn't see them.
Oh, you're fine. So one is related to the asylum case, which I'm going to butcher the last name, so I'm not even going to try it. To make an argument like that in the case, would you need to include experts every time to speak to psychological or emotional impact of harm to a child of that age? Or is there other documentary evidence that could be used, affidavits or child development information?
So my answer to that question is to use as much as you can possibly get before the hearing, which I think it's great to include affidavits. Like in the case that I was talking about, there was also testimony from the mother who could talk about how it impacted her child. So there's parents or other people that know that experience that were around at the time. There was also an expert witness who interviewed the child, well, he was older when he got there, but provided a report. So there's specific things that people can attest to that they saw how the past persecution impacted the individual. But then there's lots of studies on child's development, what this type of abuse does to a child's brain, to their ability to form attachments, et cetera, et cetera. And I would also say that children, and this is also a concept in immigration law and asylum law, is a child that sees persecution to his family members or her family members or their family members is going to be affected by, in this case that I was talking about, the threats to the family and this horrible graffiti on the mailbox and stuff. So that is something that, the court was also looking at, the harm to the child and how that impacted the child, but also think about how any kind of related persecution to the family may have impacted the child, and then look for studies and targeted documentary evidence that you can put in the record on that basis as well. The more, the merrier.
Awesome. And I think we want to wrap it up with the question section with this one kind of question foreshadowing perhaps our future webinars with NILA. And I'm also going to ask that after I ask that question, that our listeners, our viewers chime in the chat as well about what cases they think might be important. But the question is, what are some cases to watch on immigration at the circuit courts or Supreme Court? And so for our viewers, if there's cases that you're interested in that maybe you'd like us to talk about in the coming episodes, go ahead and put it in the chat, please.
So in terms of the Supreme Court, I'll answer about one case that we plan to preview when the decision comes out, and that's the Patel case. And it involves a kind of a technical issue as to federal court jurisdiction over certain types of discretionary decisions under INA section 242A2B1. And we anticipate that there will be a decision sometime this spring. And so we're planning to talk about it when it comes out at the very, whatever session we have subsequent to that.
And I will just mention another case that was just argued at the Supreme Court by Matt Adams, the Northwest Immigrant Rights Project. It was a joint case of Artiego Gonzalez versus Johnson, and then I think the other one is Gonzalez versus Rodriguez versus Johnson, and those two cases together are going to decide the issue of whether individuals who are in reasonable fear proceedings because they have either a reinstatement order or an administrative removal order under 8 U.S.C. 1228B, whether they are entitled to a bond hearing after 6 months of detention. And so it's an important detention case. And then the second case has an additional issue as to whether or not essentially like how the immigration statute at 8 U.S.C. 1252 F1, which is this provision in the judicial review section, how that should be interpreted with respect to class actions in the detention context. I'm sort of oversimplifying that, but we should see some information from the court on what it thinks about those types of cases, as well as the right to a bond hearing after 6 months for folks in reasonable fear proceedings.
Great, well, thank you so much. We just wanted to give a little information before we go about our CILA's pro bono platform. There are many children and youth who do not have representation in their immigration cases and must proceed alone, as many of you know. We host a pro bono platform called Pro Bono Matters for Children Facing Deportation on our website, and organizations from across the country can post children's cases to the platform when they need pro bono representation. And there's opportunities nationwide. It acts like a bulletin board for organizations to post cases. And many of you, if you are working for legal service providers, your organization may already post. And if you don't, you're more than welcome to contact us to find out about it. And so if you're interested in working on a pro bono case, or you have a friend who's interested, we encourage you to go to the platform webpage and to view the available cases, and you can express interest in working on a case or share the site with, or even a specific case with a friend. Some organizations are specifically seeking experienced immigration attorneys to take cases, and others will help provide resources and trainings to help non-immigration attorneys get up to speed. Our goal at CILA is to help match more pro bono attorneys with organizations' cases so that more children and youth have representation. We wanted to make sure that everyone knows about the platform and where you can either post opportunities or find opportunities. And please contact us if you're a nonprofit organization and you would like to be posting on our platform. And you can also just contact us in general if you have any questions about it. And then thank you again to Trina, Kristen, and Mary. This was a fabulous webinar, and you provided so much helpful information. And I know that we are going to look forward to a lot of stuff these next 3 in the future because it was so helpful. As we close out, please see that in the chat, there's 2 links to 2 surveys, one for feedback and one to request CLE credit. If you didn't get the slides and the handout prior to the webinar, it will be in a follow-up email after the webinar.